Well, unless the officer has another valid reason to be in your vehicle, he can't, or she can't. Look, if you don't know that something is in your car that shouldn't be there, that may be a defense, and you may ultimately be able to resolve that through the criminal justice process. But again, at what cost? Your name is in the newspaper, that you've been charged with marijuana possession. You have to go to court. You have to retain an attorney. It's a tremendous investment of time, resources, emotion. And, you know, the funny thing about these charges is when you get arrested for marijuana possession, they put your name in the newspaper. When you go to court and the charges are dismissed, they don't put that in the newspaper.
I've seen it for DWI. They do that for marijuana possession, too?
Sure. There's a police blotter in the local paper. So now your neighbors who are reading the paper and your housewives next door on Wisteria Lane now are running around from house to house with this newspaper clipping saying that the goody two-shoes soccer mom in reality is a closet pothead. So, and it's difficult sometimes to get your name back. And the process is very unfortunate. We've represented clients who have had BB guns in their car, and they didn't know that it was against the law to have this particular type of BB gun, and they were prosecuted with a firearm possession, serious criminal offense. If you're a fisherman and you carry certain types of knives in your car to clean your fish, you may not know that it's against the law to have that in your car. So one exception to this warrant requirement is when you give consent. My advice is don't do it.
Are there other exceptions?
There are. One of the most commonly used and cited exceptions in court is what's known as the plain view doctrine. And that basically means what it says. If the officer pulls you over for running a red light and he comes up to your car window and there's a loaded shotgun in the passenger seat, the officer is allowed to come in and get it. Okay?
Seems reasonable.
And there are certain requirements that the courts will place upon the officer. It needs to be he needs to observe that from what's called a permissible vantage point. He can't stick his head in your car and look around. It needs to be immediately apparent that the item is connected to a crime.
What happens if the officer doesn't follow these guidelines, doesn't have reasonable suspicion, or doesn't get a warrant and finds something anyway? Can it be used against you?
Unless there is a warrant or a valid exception to the warrant requirement, that information and that evidence will be suppressed. Not only that evidence, but anything else that the officer finds. In the law, we have a doctrine called the fruit of the poisonous tree doctrine, and it basically stands for this proposition. If the search is deemed unconstitutional, invalid, if it's poisoned, then any evidence resulting from that search, any fruit that's yielded from that tree, is also deemed poisonous. And this drives people crazy because they see it on the news all the time. Some guy is stopped in New York and he has 500 pounds of cocaine in the back of his trunk, and it turns out that the officer wasn't supposed to be there, and it all gets thrown out. It doesn't matter what they find. If they come into your car and they shouldn't be there, it doesn't matter if you have in your back seat a gun, drugs, a dead body, a prostitute, and a bootleg copy of Toy Story 3. They can't use it. It all gets thrown out.
All right. On that note, we're going to go to a short break. Please stay with us for more about municipal court system here on Outlook Monmouth.
Do you know that stroke targets by color? Odds are, if you're African American, you're twice as likely to suffer a stroke as white Americans. Know where you stand, because beating the odds isn't about winning, it's about living. Join the power to end stroke at strokeassociation.org.
Redefine your world. Join the Peace Corps.
Apply now at peacecorps.gov.
Welcome back to Outlook Monmouth. I'm your host, Armin McCumber. If you're just joining us, we're talking about the municipal court system with Albert Mollo, a local criminal defense attorney. Mr. Mollo is the managing partner of Mollo Law Firm with offices in Red Bank and New Brunswick. Typically, Al, it's pretty good advice to have an attorney before you walk into any court. Is that the case with the municipal justice system, or can people feel confident to sort of go it alone? And I have to say, by the way, that's not a loaded question. I mean, it seems like most people do go it alone, don't they? Or try to, anyway.
In municipal court, a lot of people do try to go it alone. And, frankly, you have the right in this country to represent yourself, regardless of what you're charged with, to speeding ticket or murder. You can represent yourself. Anytime the state puts a requirement on you to appear in court, you should have an attorney. And in municipal court, where some of these offenses are upon first glance, seemingly insignificant or minor offenses, they can present substantial consequences for you, financially or otherwise. As you mentioned at the top of the show, fines, surcharges, in some cases jail, loss of license. So it is critically important at the very least to consult an attorney prior to going to court. There are practical advantages to having an attorney.
Such as what? In
the municipal court system, for instance, judges are required to handle attorney matters first. So you have your court date at 9 o'clock in Middletown, and you need to be in work by 9:30, and you don't want to spend the whole day there waiting for them to call your case. Well, you show up with your lawyer, your attorney resolves the matter with the prosecutor, hopefully, and the judge puts your case through first, your case along with the other attorneys. Additionally, when you walk into the court, for someone who's not familiar with the process, it's very confusing, it's very overwhelming, there's a lot of people, there's police officers, there's the judge, you don't know what to do. When you have an attorney, your attorney says, sit here, do this, do that, and usually your lawyer could do all the talking for you. So there certainly are practical advantages, and there are substantive advantages. These cases, some of them require a sophisticated approach and a sophisticated analysis of some of these legal issues. And there are sometimes defenses, even to more minor charges, like speeding, that you may not be aware of, where your lawyer can save you a considerable amount of money or worse. Potential insurance consequences, again, potential action that the Motor Vehicle Commission can take on your license. And so, as a general rule, at the very least, you should always consult an attorney. I recommend clients, even clients that I consult, I recommend that they consult with more than one attorney.
When you get to court, what do you need to know? What should you expect about the process?
Well, rule number one is be on time. That upsets the judges when you're late.
It's true of lawyers too,
and it's true of lawyers, right? We get away with it a little bit more than the clients do, but be on time and look nice. I certainly don't pass judgment on any of my clients for their choice of dress. And even though some of the judges here in our county are pretty hip, you don't want to be going to court with a, if you have a big blue hoop earring out of your bottom lip, take it out.
So the judges tend to be, conservative somewhat, at least culturally.
I certainly don't mind if a client has green hair, but, a judge might. So I usually tell my clients, to tone it down, stay away from jeans and shorts and baseball caps, obviously. You don't need to wear a three-piece suit, but, look nice, pair of slacks. Get the J. Crew catalog and look at, get yourself a nice button-down shirt. So be on time, look the part, and, you always want to show deference to the institution.